Friends, I just pressed the let's go live button, so let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. We got to make sure the tubes are working, and they better be working today because we've got some serious business to attend to, and they are, so that means we can get started. Let's get to it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Trump. We have the motherlode of documents that came out from his defense. You know, some mornings you wake up and you check the Trump docket. I don't know what the first thing you guys do in the mornings, but, you know, that may or may not be one of my routines. What's going on out there? And some mornings you're like, meh. And other mornings you're like, holy Toledo! It's like Christmas in October. And that happened today. And we've been waiting for this, right? We've been saying that there's just going to be a rapid fire of motions. And look at all these. You can see we open up the node on the mind map. Boom! That's what we've got. And so today, we're not going to be able to get to all of them, but here's the plan. So we're going to go through them in turn throughout the rest of this week and maybe in the next week because there really is that much. And so I want to spend today talking about this one. It's 31 pages, so we'll hit this one. It's a motion to dismiss for constitutional violations, and that's going to be the segment on the day. We'll take a look at the docket. You can see, man, just a big slew of motions, and there's actually more than the four. I mean, there was other stuff that came in previous to those. And so we'll go through the highlights of the motion to dismiss for the constitutional violations, and we'll spend some time on it. I mean, I really want to, sink our teeth into it. And then later on in the week, so make sure you're subscribed and, turn those notifications on. But later in the week, we'll go through the remainder. So tomorrow we'll do the one on a dismissal based on statutory grounds, saying that the law, the Constitution is separate from the law, the statutes that come on top of the law. And so he's going to try to dismiss on that basis. We've got another one that we'll probably get to on Thursday, which will be a motion to dismiss for selective and vindictive prosecution, calling deranged thug Jack Smith a deranged thug, more or less, without saying that. And then we've also got a motion to strike some of the inflammatory statements, right? In the original indictment, they were talking about insurrection and democracy and blah, blah, blah. They're saying a lot of that stuff is not necessary to the actual charges. So they want to strike some of those inflammatory statements away. And so, well, that's the plan. I mean, very excited. I don't know about you, but I was jumping out of my seat this morning. So that will be on the agenda today and the rest of the week. So make sure you're joining us for that. Then we're going to turn our attention to what happened over in the Cohen trial, or the Trump trial involving Michael Cohen. And he came into court and testified against Donald Trump today. And Donald Trump was there in the courtroom himself. And so we're going to see what went down today in court. I've got a couple clips from inside. Donald Trump, I don't think, gave a big statement today, but he did wreck the GOP scam to try to install Tom Emmer, which is interesting. But Trump is going to be reacting to Cohen. Cohen was there, seen entering the courtroom. And so we'll go into the courtroom affairs courtesy of Adam Klasfeld. He's reporting now for The Messenger, and he put together a trial thread. I think he was in there, and he saw Tishy and everybody come in and show up. So we'll see what's going on in there. And just a reminder, I always like to remind everybody here, sometimes we have to refresh our recollection, but Michael Cohen is a convicted perjurer. Okay, he lied to Congress, signed a plea deal, admitting guilt to that. So I don't know why Tish would invite a convicted perjurer to come into the trial to testify, but she did. Just as a reminder, he's a convicted perjurer. Now, we also have this story on the day. And boy, oh boy, my friends, am I excited about this one. Now, we were waiting here to see the actual documents. Okay, we've been following these plea deals here for some time now. Sidney Powell, Kenneth Chesebro, and we were watching the court proceedings, but they were very obfuscated. Okay, they were very difficult to unpack, and that was by design. And I know that, and I'll explain that later. But what we have unpacked here, what we have discovered is that Fani Willis's cases are even more beneficial to the defendants than we thought. Put another way, Fani is even a bigger failure than we thought. And we can now, I can confirm this, that we can call these traffic school plea deals. That's the new vernacular here. We like to simplify things. Many of you have been convicted. Let me back up. Not convicted. See that? Easy to make a mistake, but we'll come back to this. But many of you have gone through this traffic school process, right? Where you get charged with a speeding ticket, a big no-no. You contest it. You say, I didn't speed, whatever. But you decide that you're going to sign up for a class, take a 4-hour online course. The ticket goes away. You spend some money. The government gets paid, and everything goes bye-bye. That's exactly what's happening in these cases, okay? They're going to go bye-bye because these are all deferred prosecutions. These are deferred adjudication dispositions. And we're going to unpack this because we went and dug up the document that this is Sidney Powell's final disposition. And we're going to unload this and show you exactly what the judge writes in here that says Sidney Powell's charges, so long as she complies with probation, pays her fines, all the stuff, will literally be exonerated. Her case will be sealed, and it is as though she is never convicted at all. So Sidney Powell, one of the chief architects, one of the people that we saw with the Kraken and all of the things, one of the masterminds behind the whole insurrection, the greatest attack on America since the Civil War, is going to have her case literally dismissed, gone. And so we posted this over on X today. It's got a little bit of a reaction over there, but somebody, well, we'll leave this. I'm going into the segment here. I'll just, that's what we're getting into. All right. Getting ahead of myself. I'm so excited. All right. So we got so much to get to, but the big story was Jenna Ellis went through a change of plea proceeding. Now, she entered a guilty plea and went through the proceeding, but the judgment was not entered. Okay. The plea was accepted by the court. A lot of nuance here, but it was not entered as a judgment. And that means she's in the same category, and her case is ultimately going to be dismissed as well. So Fani is losing. No convictions, not even any guilty judgments. Okay, so every time you hear guilty plea, forget about that. It's traffic school. They're going to take some time off, go on probation, and that's going to be it. Amazing. So we're going to go through all that and more, my friends, and we'd love it if you joined us. Now, one great way to support our show and the work that we do is to become a member. 2 ways to do that. One, going over to watchingthewatchers.locals.com. We really try to deliver for our members, no matter where you join us, on Locals or on YouTube. We have member-only streams in the morning, so we jump into the day's affairs and try to get our bearings straight before things really start to unwind. And then we also do Saturday shows, and we got a lot of other cool stuff cooking, and we'll share that soon. But join us, watchingthewatchers.locals.com, and meet some other cool people in our community, and stick around for the after party, which also takes place after the show. So members, we like to debrief after the show is over. We've also got our website, robertgouveia.com. And if you scroll over there, you can sign up for our daily newsletter so that every day you'll get all of the segments and the daily reports that are associated with those segments delivered to your inbox. So if you can't stick around for the full show and you're like, I wonder what's just going on, what did I miss? That will come right to your inbox. Just go to robertgouveia.com, sign up for it. And then, if you don't want them, just delete them. Just delete anything here, no delete. Anything, no delete. Not a big deal. And so just check it out, robertgouveia.com. All right. Now, let's get into it because we've got some business to attend to. Starting with Donald Trump's defense files a motherlode of motions to dismiss, among other filings, and we're going to go through them. Now, there are so many to attend to here that today we're going to be focusing on this one. The motion to dismiss for constitutional violations is a 31-pager, but when I saw this docket, I was pretty excited about it, and I wanted to share it with you. Take a look at this. We've got a lot. If you go over to the actual court docket, here's what it says: U.S. versus Donald Trump. And we just had boom, 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 boom. We had a motion to dismiss for selective and vindictive prosecution. And we've got a main motion on that to dismiss the entire case because Jack Smith is a deranged thug. That comes with additional attachments. We've got a motion to strike for the inflammatory allegations out of the indictment, get rid of those. Another motion to dismiss based on the law. Another motion to dismiss based on the Constitution. And other responses by Donald Trump that are really leading to a lot of activity on this case. And we've been waiting for this for some time. And so we're, of course, going to be going through each of these in turn because this is a historical case. This is one of the cases that will, I think, define the future of America, and it will be etched into the history books no matter which way this thing goes. And so as we go through this, now today we're only focusing on the constitutional violations motion. So be sure you're subscribed if you want to make sure to get and catch the other filings when we get to those. But let's just get right into it. This is what has been filed. Now, this one, 31 pages. This is Judge Chutkan's courtroom out of the District of Columbia, United States of America versus Donald Trump. And here's the filing. It says, President Trump's motion to dismiss the indictment based on constitutional grounds. You violated Donald Trump's constitutional rights as a citizen, as a former president, in many different varieties. Let's see. Judge's defense, Trump's defense, opens. Your Honor, the prosecution in this case opens its indictment by stating that President Trump had a right, like every American, to speak publicly about the election. That's what Jack Smith said, including his deeply held view that there had been fraud and other irregularities during the election that he had won. Trump people, they say, these points are not in dispute. We agree, he did have a right. But nonetheless, in an astonishing display of doublethink, Jack Smith deranged thugs and his prosecutors simultaneously claim that President Trump, simply by speaking his mind and by petitioning for a redress of grievances that we thought was protected under the Constitution, also somehow conspired to, quote, defraud the United States and to oppress rights and to obstruct an official proceeding by doing those things, by simply speaking his mind. Now, attempting to explain this obvious contradiction, the prosecution argues that there was no outcome determinative fraud in the election. In parentheses, their words, not mine, whatever that means. I know it's hard to disambiguate that because sometimes that sounds like me, sounds like something, whatever that means. But no, they put that in the motion. There was no outcome determinative fraud in the election, whatever that means. And that President Trump supposedly knew this because some government officials, quote, notified him that his claims were untrue. Okay, Bill Barr comes over, Donald Trump, he's waddling his way over there. And he then sits down with Trump and he says, we've done our due diligence and the DOJ says there's no fraud. Trump says, thanks, Bill, get the hell out of my office. So the defense says, now, if there is any constant in our democratic system of government, it is that the marketplace of ideas, not the mandates of government functionaries or partisan prosecutors, that determines the public debate scope. The marketplace of ideas determines what we do, not government bureaucrats. They say countless millions believe, as President Trump consistently has and currently does, that fraud and irregularities pervaded the 2020 presidential election. And as the indictment itself alleges, President Trump gave voice to those concerns and demanded that politicians in a position to restore integrity to our elections not just talk about the problem, but also to investigate it and resolve it. They say that the First Amendment embraces and encourages exactly this kind of behavior. That's why we have it. And therefore, they stated in the clearest of terms in the First Amendment that, quote, Congress shall make no law abridging the freedom of speech or the right of the people peaceably to assemble and to petition the government for a redress of grievances. United States Constitution, First Amendment. The indictment, taken as true, if we say Jack Smith is honest and accurate and not a deranged thug, I know it's difficult to do. If taken as true, the indictment itself violates this core principle as to each count. Accordingly, the court should dismiss this indictment in its entirety. They say now, additionally, Judge Chutkan, as the United States Senate has previously tried and acquitted President Trump for charges arising from the same course of conduct alleged in this indictment, the impeachment and the double jeopardy clauses both bar retrial before this court, and they require dismissal. He's being prosecuted again for conduct that he's already been prosecuted for in the United States Senate, and he was acquitted there. So just like you can't be charged twice for the same crime under the double jeopardy provisions, same concept applies. They say, finally, because our country's long-standing tradition of forceful political advocacy about perceived fraud and irregularities in numerous presidential elections President Trump lacked fair notice that his advocacy, in this instance, could be criminalized. Thus, the court should dismiss this indictment under the Due Process Clause as well. Due process is the idea that the government can't act and do things against you without you being afforded proper process. So if they're going to arrest you, right, or interrogate you, right, they want to read you your Miranda rights to make sure that those are being protected. That's part of giving you due process, to make sure you know about your rights. So the same thing happens here. If Trump doesn't have notice of the law, right, you just can't criminalize something. Hey, just pass a law. It's illegal to make a left-hand turn after 4 p.m. And then the cops just sit outside. Everybody who makes a left-hand turn gets arrested. You're like, what? We had no notice. That's a violation of due process. And by the way, they used to do that. Okay, something you're arrested. Why? The law changed. What? It's now illegal to be a shopkeeper here. Okay. So it was a big part of this. And Trump was doing and saying the same thing that a lot of other Democrats were doing. Fight like hell. We had, that ranting psycho from California, I think. Many of them. I know it's hard to keep track. But, screaming and shouting, get in their faces, fight. And, Hakeem Jeffries was objecting to the elections of Trump, and they all did the same thing, right? So if they didn't get prosecuted and Trump was doing the same things, he should not get prosecuted either. They say, Your Honor, here's some of our argument. They say, President Trump fully denies the allegation in the indictment, which are referenced here, and we think this is sufficient to dismiss this entire case. Here's why. First and foremost, they say Jack Smith's indictment must be dismissed because it seeks to criminalize core political speech and advocacy that lies at the heart of the First Amendment. In other cases, the Supreme Court has confirmed that we have a broad scope of the First Amendment in this country, and it protects even the verifiably false claim that the Speaker had been awarded the Congressional Medal of Honor. Okay, somebody came in, I got a Congressional Medal of Honor. Turns out he didn't, lied about it, but he's allowed to say it. That was a plurality opinion. It produced multiple opinions, but on one key point, all 9 justices were unanimous. They said, under the First Amendment 9-0, the government may not prohibit or criminalize speech on disputed social, political, or historical issues simply because the government determines that some views are true and others are false. Our constitutional traditions stand against the idea that we need Oceana's ministry of truth. That's from George Orwell's 1984. So you're allowed to have a different opinion than your bureaucratic, useless government. Our Supreme Court said that 9-0. Now, the 4-justice plurality, okay, this is where the justices have kind of a different opinion. We're used to hearing opinions like 7-2, or 5-4, or 9-0. But sometimes what will happen is you'll get these plurality opinions where there will be like 3 or 4 issues in a case. We'll have like a free speech issue, we'll have like a due process issue, we'll have an equal protection issue, whatever. And in the court, the judges will split on those, or there'll be one issue and they say, well, we kind of think this way, but this or this, and it's really complicated. And so what it makes, it's actually very difficult for lawyers to tease out of that what it all means. And so they're telling us, well, 4 judges, they agreed with this. They said they were emphatic on this point. So 4 of them, 9 of them agreed on this one issue, that you can't criminalize speech based on government dictated truths. And another 4 of them, they rejected the notion that government may decree that this speech about receiving medals to be criminal. Now, whether it's shouted from the rooftops or made barely audible, such an approach would endorse the government authority to compile a list of subjects about which false statements are punishable. Okay, so if that guy is charged with lying about his Medal of Honor, the government can say, that is our truth, and we've made it, you can't challenge our truth, and that leads to a big problem. says the government has no clear limiting principle. We protect free speech that much. So disavowing Oceana's Ministry of Truth, Justice Kennedy rejected any rule that would give the government a broad censorial censor power unprecedented in this court's cases or in our constitutional tradition, saying that the mere potential for the exercise of that power casts a chill that the First Amendment cannot permit if free speech, if free thought and discourse are likely to remain the foundation of our freedom. Here, now, it's just amazing when we used to think like this. Said the remedy for speech that is false is speech that is true. The remedy for speech that is false is speech that is true. See how easy that is? Very simple, not even complicated. Now we need disinformation boards, and now we need big governmental laws that censor people. We need Elvis Chan from the FBI snooping in your DMs on X. Or the White House doing the same thing, which they're now allowed to do thanks to the SCOTUS. We made a video about that in another segment. Very simple. We don't need to be censored. We don't need people to tell us what's true or not. If people are posting misinformation from video games about explosions in the Middle East, that's fine. Let them post it. Post a response to that. That's true. And those people who are posting misinfo eventually will be found out for what they are. Now, this is the ordinary course in a free society. Would have been nice if our government had listened to this concept back during COVID and before. Now, the response to the unreasoned is the rational. Simple. Doesn't make sense, just rationalize it away. To the uninformed, the enlightened. To the straight out lie, the simple truth. The theory of our Constitution is that the best test of truth is the power of the thought to get itself accepted in the competition of the market. Freedom of speech and thought flows not from the beneficence of the state, not thanks to the government giving us our freedom, but from the inalienable rights of the person. They are your rights and they cannot take them away. And when the FBI says that your content is dangerous to the America for whatever reason, or to their narrative, that is them violating not only your constitutional rights, but your inalienable rights as a person, as a human being. And suppression of speech by the government can make exposure of falsity more difficult, not less so. When the government gets in and meddles, we have worse information, not better. These ends are not well served when the government seeks to orchestrate public discussion through content-based mandates. Good comments there. They say, now only a weak society needs government protection or intervention before it pursues its resolve to preserve the truth. That's why we call many who want to do this censors and cowards and bullies, because it's weakness. They're weak. Their ideas can't survive in the marketplace of ideas, so they have no choice but to act like pathetic weaklings. Truth neither needs handcuffs nor a badge for its vindication. The truth shall set you free. All common jurisprudence and accepted in our country for 230 years. Now, Justice Breyer's two-justice concurrence in Alvarez likewise endorsed this point, and Justice Alito said there are broad areas in which any attempt by the state to penalize purportedly false speech would prevent a grave and unacceptable danger to suppressing truthful speech. Now, these topics, which are often the subject of vigorous public debate, rarely have clear or verifiable answers. That's the point of the controversy. That's why we need free speech. That's why citizens must be given breathing room to speak their minds without fear of being criminally prosecuted by deranged thugs. Breyer also concluded that the threat of criminal prosecution for making a false statement can inhibit the speaker from making true statements. It chills legitimate speech. And that speech is the exact speech that the First Amendment protects. Judge Alito also had an opinion. The opinion least protective of speech was this one. His dissent recognized that there are broad areas in which any attempt by the state is unacceptable, dangerous to this, but it is perilous to permit the state to be the arbiter of truth, right? That is the opposite of what we want. So they make the argument there's a broad consensus here. There is unanimous consensus that widely disputed social, political, and historical questions, i.e. matters of public concern, are matters that are protected by the First Amendment. And this is great, okay? So this is going to give the Supreme Court something to latch onto. So you see what they've done here, kind of this matters of public concern thing, and they're wrapping all of this. They say here, Justice Alito, right? Let's endorse this new concept here. Alito's discussion demonstrates that such claims are protected by the First Amendment, especially when the government says they're false. They're even more protected. If the government comes out and says, oh, no, absolutely, that's not true at all. That's the whole point of the First Amendment, is to challenge that. So when all of Trump's own government comes to him and says this is the situation, he can reject that, just like he can in any other situation. Hey, Trump, you should sign this bill. No, I'm not going to do it. Hey, Trump, you should invade this country. No, not going to do it. Hey, Trump, you should concede the election. No, I'm not going to do it. Go do what I've ordered you to do. So especially, and he can come out and say, no, this was all rigged, especially when his own government says it. So claims about the integrity of the election, including claims that the election was, quote, rigged, stolen, and or tainted by outcome determinative fraud, every one of those statements are fully protected by the First Amendment, regardless of the government's view of their truth or falsity. Because if the government could say that's not true, you're not allowed to say that, they could indict you for anything that they deem to be false. So otherwise, it would be perilous to permit the state to be the arbiter of truth. Now, this conclusion, that the First Amendment fully protects opinions and claims on widely disputed issues like 2020 elections, draws from other of the most basic principles of First Amendment jurisprudence. Here, these claims constitute, one, everything that's happening here, they are Trump's core political speech, which is at the crux of the First Amendment. They're also matters of enormous public concern. And they say that if in this situation, because they're core political speech about matters of enormous public concern, any suppression of those statements would constitute forbidden viewpoint discrimination. And so you can think about the discrimination, let's just use the word discrimination, or let's say regulation. The government might be able to regulate certain speech conduct, but not others. And a lot of the times you can distinguish this by either content or context. So for example, you might not be able to blow a bullhorn out in front of City Hall at 2 a.m. legally, right? There might be a time, manner, and place restriction about where you can protest, what you can do, so that you're not creating a ruckus in the middle of a neighborhood protesting and rallying, right? There might be noise ordinances and things like that. That's all legitimate because you're not saying Trump can't talk about that, or this group can't talk about this. If you said that only pro-lifers are not allowed to blow bullhorns in the middle of the road, but everyone else can, that would be a content-based restriction. So the context is around where are you, what time of day is it, and that type of stuff. But when they get into viewpoints, right, when you just say Trump can't question an election, that's not context. That is content. That's his opinion. And as the president, he's entitled to them. In fact, he was elected to give them to us. And the reason many of us voted for him, or one of them, was because of that. So they say, Your Honor, look, it's pretty obvious. Okay, the things that Trump said are clearly speech that is being done on matters of public concern. Matters concerning public affairs is more than just simply self-expression. It's the essence of self-government. And this is why also Chutkan's gag order, right? As we go through this, like all of this can also apply to the gag order itself, not just the entire prosecution. So they say here, speech on public issues occupies the highest rung of the hierarchy on First Amendment values, and it's entitled to special protection. That comes from a U.S. Supreme Court case in 2011. Saying that speech deals with matters of public concern when it can be fairly considered as relating to political concern of the community, or when it's subject to legitimate news interest, or when it's subject to the general interest and value of concern of the public. Does Trump contesting the election fall within all of those categories? I'd certainly say so. They say here, indeed, such speech constitutes core political speech. And the First Amendment, when we're talking about this type of speech, is at its zenith. So if you put speech on a spectrum, when it's core political speech, man, that is like ultra strong. You are force fielded up. But if you're making a threat, you're not as protected, right? And you go through the Brandenburg test. Is it imminent? Is it likely to incite violence and those things? And if you run through that test, then it falls off the scale of protection. But if it's questionable, right, it gets closer onto that end. I don't know. But this is in a very special category. They say, we also know that attempts to prohibit or criminalize claims based on political disputes, so Trump says it was rigged, therefore that's illegal, inevitably target speech on the basis of viewpoints, which is the least tolerable of First Amendment violations. Another Supreme Court case, this one from 1995, saying when the government targets not subject matter, but particular views taken by speakers, the violation of the First Amendment is all the more blatant. Viewpoint discrimination is thus an egregious form of content discrimination. And the government, this is quote, must abstain from regulating speech when the specific motivating ideology or the opinion or the perspective of the speaker is the rationale for the restriction. So because Trump was challenging the election, his speech is even more powerful. You have to have a really good reason for saying that's illegal and that's criminal. And up until this time in American history, it has never been criminal. So the fact that the indictment alleges that the speech at issue was supposedly, according to the prosecution, false, they said, no, we said it's false. Therefore, they say it makes no difference. Under the First Amendment, each individual American participating in the free marketplace of ideas, not the federal government, decides for him or herself what is true or false. We get to pick. They say our constitutional tradition stands against the idea that we need a ministry of truth. Otherwise, there would be no limiting principle. But Jack Smith, deranged thug, and his indictment attempts to criminalize core political speech and political advocacy. But this indictment does not merely criminalize conduct with a small incidental impact on protected speech. No. Instead, this indictment directly targets core protected speech and activity. They're not just saying, Trump did something bad and that he might, like, let's say, a murder or something like that. And that because he's being charged with a murder, which resulted, in a dead person, that there's some ancillary collateral consequence for his free speech rights. No, they're saying that his exercise of free speech was the murder. Okay, that's like the body of the crime. How can you possibly say that? For this reason, it is categorically invalid. You can't charge somebody for this. They say, quote, this one from another U.S. Supreme Court case, 1972, says clearly government has no power to restrict such activity because of its message. But that's what Jack Smith is trying to do here. So for similar reasons, the indictment is invalid, gone, under any level of scrutiny. As noted above, the indictment imposes viewpoint-based restrictions on core political speech on matters of the highest public concern with extremely severe penalty. And thus, if any scrutiny applies, it is the strictest form of scrutiny. Now let's pause for a quick minute. When we talk about whether the government violates your constitutional rights, we always ask ourselves very roughly, what did the government do? What was the action of the government? And how do we review the action? What rules do we apply to that conduct? So in criminal court, for example, what are the rules? Well, it's beyond a reasonable doubt. That leads to a conviction. If a person shows that this was done, the government shows it was done beyond a reasonable doubt, conviction. If not, no conviction. Okay, those are the rules. For constitutional issues, we have three different sets of rules. It gets a little more complicated. So we have what's called rational basis review, which is actually the lowest standard. Then we have intermediate scrutiny. Then we have what's called strict scrutiny. And depending on what the government is trying to impose upon you and impede, we ask ourselves, what level of scrutiny do we jump into? Is it rational basis? Is it intermediate scrutiny? Or is it strict scrutiny? And when you're talking about a constitutional right, the default is up to strict scrutiny because it's a constitutional right. Now, if you say something like, I have a right not to pay my speeding ticket or something under the Constitution, they're going to say, no, that's not really a constitutional right. Driving is a privilege, it's not a right, and you contract with the state to get a license, and so you've got a speeding ticket, so you got to pay your ticket, and if you don't want to do that and you file a constitutional thing, you're going to go to civil court, and they're going to say, well, civil speeding tickets, they're allowed. States have the right to regulate themselves, and so we're not going to say that it's an impingement on your constitutional right to drive, and so therefore, rational basis review will be appropriate, and your constitutional rights are not violated, pay your ticket. Something like that. So here, this is a core protected First Amendment activity. This is political free speech, so it obviously has to go to the strictest form of scrutiny, which is very high, like extremely high. But regardless, the prosecution cannot show any interest, let alone a compelling or substantial one, in punishing such First Amendment protected activity in order to meet that rule of strict scrutiny. The prosecution has no valid interest at all in silencing disfavored viewpoints or preventing people from advocating disfavored viewpoints to other government officials. This indictment is precisely tailored to violate free speech rights, not narrowly tailored to avoid them, which is what the law says. The law says that in order for them to, under strict scrutiny, to be allowed to violate your constitutional rights, it has to be basically absolutely necessary for the government, like there's nothing else they can do at all. And what the action is, it's the most restrictive. It's narrowly tailored to be least violating. Okay, so it's going to minimize the constitutional violation to the maximum extent possible. But he's saying it's not doing any of that. Okay, literally, it's orchestrated to specifically violate his free speech. Now, this is the antithesis of narrow tailoring, so it fails. Finally, if the indictment validly applies the language of the statute, that renders the statute both unconstitutional as applied and unconstitutional on its face under the First Amendment overbreadth doctrine. And so under their interpretation, the statute sweeps in the criminalization of large amounts of pure speech, and thus it suffers from overbreadth that is not only real, but substantial as well. And so you can see now they're going to get into the meat and potatoes. So we're going to fast forward through some of this and just see what's here. First Amendment, obviously, they say extends to statements advocating for the government to act. And they give us another case called McDonald. We see here some excerpts. This conclusion from McDonald. So we're going into some analysis and application. They say here, the First Amendment also does not permit the government to prosecute a citizen for claiming that the election was stolen. They say here, the prosecution cannot criminalize claims of the presidential election being stolen, and it cannot seek to impose its view on anybody who thinks that way. Claims about the 2020, including claims that it was rigged or stolen, implicate all the First Amendment fundamental principles in this country. And so if they can prosecute Trump for saying it was rigged, can they prosecute all of us? This is especially true because claims of 2020 that it was rigged or tainted by fraud, these don't involve easily verifiable facts. Okay, other cases you just know it's true or not. But many millions of reasonable people, including yours truly here, believe that the 2020 election was unfairly rigged against President Trump. And you can just point to the Hunter Biden laptop cover-up. You can point to the FBI collusion and censorship scam that was in place. You can point to the CIA and the 51 so-called intelligence experts who signed a letter to lie to all of us, who were colluding literally with Anthony Blinken from the Biden campaign, who he then made Secretary of State. The whole thing was rigged. They had the COVID scoreboard death counter on every day. Look at Trump, more dead people. Trump, dead people. Then as soon as the election's over, they changed it to green, and it's the how many people got the jab, right? Joe Biden's bringing the jab to America. What the heck is going on here? So the whole thing was rigged. And by the way, that doesn't even get into all of the election rules that were changed that we covered here on this channel. I can't even tell you how many lawsuits we covered in the run up to 2020. We were screaming from the rooftops that they kept changing the rules due to COVID. They waived signature requirements. They waived all sorts of other registrations, moved deadlines back, authorized ballot box collections, the whole deal. So yeah, there's a lot of us that say that there were a lot of problems with the election. Now, there is an abundant public evidence providing a reasonable basis for these opinions. I just listed some of them. What is critical is that how one interprets this evidence depends on one's deep-seated political views. True, and I would also say reality, including one's trust in government institutions, zero here, and government officials, among others. Now, different people will draw different inferences from what they see. But guess what? That's what the First Amendment permits. That's what we're supposed to do, is have these debates. So this unconstitutional dynamic on the face of the indictment itself is showing this is unconstitutional. It repeatedly says that Trump knowingly made false claims of election fraud. But in every case, the indictment's basis for the allegation that Trump's claims were knowingly false is that, quote, a member of the political establishment assured Trump that they were false, okay? So we have to ask ourselves, right? They're going to come, Trump stole the election, insurrected America. No, okay, calm down, psycho, hysterical person. Tell me specifically what it was. What conduct? In the indictment, because they got to prove the indictment, and it's got to be specific conduct. So Trump's defense is saying, look, here's what they said. Every indictment that says Trump made a knowingly false statement, how did Trump know it? How did they read his mind? How was it knowingly? A member of the political establishment told him so. That's great. Just because somebody tells you something doesn't mean that you believe that. So under the First Amendment, Trump and his supporters are entitled to mistrust the word of the government and draw their own inferences from the fact, and I think we've been proven true. And neither the federal government nor the judicial branch may dictate what President Trump and others are required to believe or to say about this hotly disputed political question. Now, the government, they can come to their own conclusions, of course. It can hold hearings and conduct investigations, and it can establish its viewpoint. It may insist that the opinions of others, including Trump, are wrong or baseless, as they did, or stupid, or they can even say they're false and malicious. But the government may not require Americans to subscribe to its views or to punish them for expressing or advocating. Now, to do so violates the First Amendment. And under the First Amendment, the question of whether 2020 was stolen from Trump must be decided in the marketplace of ideas, not in criminal prosecutions. And so this case should be dismissed. We also know that Trump was tried in the Senate and he was acquitted. And under our system of separated powers, the executive branch lacks authority under Jack Smith to second-guess the decision of the legislative branch, Congress, on an issue that lies within the legislative branch's exclusive purview. Congress made a decision on this. The executive branch cannot usurp them. We have separation of powers for a reason. They've already come to their conclusion. The Constitution's plain text, structural principles of separation of powers, the principles of double jeopardy, they stop the executive branch from trying to recharge and retry a president who's already been impeached and subsequently acquitted. He's already had the trial. Now, to be removed, we've already gone through this at length here, so we'll fast forward through this, right? Remember, the Constitution says, after a party has been convicted in the Senate, then they shall be held liable to indictment, trial, judgment, and punishment. So, impeached in the House, trial in the Senate. If you're convicted, which Trump never was, then you can be indicted and prosecuting according to law. But because it's a political position, you deal with it politically first. Now, because the Constitution says that, Your Honor, it's all well-founded, and it reflects the original meaning that we've seen elsewhere in the Federalist Papers, and they're going back to some other arguments. Now, they say here, in this case, President Trump is not a party who has been convicted in an impeachment trial by the Senate. He was impeached in January 21 by the House on articles arising from the same issues in this indictment. They impeached him after January 6. Among other things, in the articles of impeachment, they put this in here, that Trump repeatedly issued false statements asserting that the election results were the product of widespread fraud and should not be accepted by the American people, and that Trump made false claims in a speech, and that he engaged in prior efforts, whatever that is, to subvert and obstruct the certification of their results, including a phone call, and he threatened the integrity of the democratic system. And guess what, Judge Chutkan? The indictment here rests on the very same alleged facts, all the same. President Trump was already acquitted after a trial in the Senate, and therefore he is not a party who's been convicted under the Constitution, and therefore he's not subject to being indicted for the same course of conduct. It's political because Congress impeached him for it and tried him for it. And to avoid partisan criminal hack prosecutors, our founders required a much bigger threshold to actually impeach somebody and convict them in the Senate. That did not happen. So they don't get the opportunity to just charge him, in 100 different jurisdictions until they get a conviction now. Trump is immune under double jeopardy, essentially. Presidential double jeopardy, if you want to call it that. So in sum, under the Constitution, the executive branch, including the prosecution, because the DOJ and Jack Smith belong to Joe Biden, they lack the authority to second guess the acquittal that was already made by the Senate. This is good. And the body to which the Constitution explicitly entrusts this authority. To do so violates the impeachment clause and the principles of separation of power by unlawfully encroaching in the authority that's already been vested to Congress. And so because this is barred, the Fifth Amendment comes into play as well. Double jeopardy applies. No person shall be subject to the same offense twice. And we've got a separation of powers issue. And also, Trump didn't know that he was going to be indicted by partisan prosecutor hacks. Here's what they say. They say this indictment charges that President Trump with crimes arising from his political advocacy on matters of public concern in the middle of a disputed election. And quite frankly, Trump was inspired by, and he was acting fully consistent with other examples in other contested elections. For example, a long history in our nation, dating back to 1800. We had elections 1800, 1824, 1876, 1960, 2000 with Bush, 2004, 2016 with Trump, and all the Democrats were screaming from the rooftop on that one, among many others, of disputing the outcome of close presidential elections, publicly claiming everybody comes out, that the results are tainted by fraud, everyone files legal actions, that everyone's lobbying, everyone is trying to not certify, and everyone's disputing the results, organizing alternate and contingent slates of electors. In other words, all the chief alleged acts in the indictment, every single thing that you're charging him for, they all have a long historical pedigree in American electoral history. And they've all been long decided in the political arena. President Trump is the first person to face criminal charges for such core political behavior as disputing the outcome of an election. He is charged, moreover, under statutes that have facially nothing to do with his alleged conduct and whose language the special prosecutor stretches beyond recognition. As a result, Trump could not possibly have received fair notice that this was criminal, and this should be dismissed as a violation of his due process rights to receive proper notice under the United States Constitution. And so we can see they continue to give us some more historical precedent for that, and they give us a closing paragraph. They say, at the time of the allegations in this indictment, the only relevant precedent from 2000 treated post-election challenges as lawful. And actions listed in the indictment, the things that they say were criminal, they'd been performed in a number of other elections, 1800, 24, 76, 60, without any criminal charges. Scores of people have been involved in similar conduct over the years of American history, and none, not one, has faced criminal prosecution in the last 234 years. On these facts, at best, men of common intelligence must necessarily guess if President Trump's conduct violated the statutes, and thus the Due Process Clause is violated. Saying that the court, therefore, Judge Chutkan, you should dismiss this indictment for violating Trump's constitutional rights and dismiss it with prejudice, meaning you can't come back with this. It's done and over and gone. Submitted, love this argument, by John F. Lauro. I think that what we saw from Todd Blanche and these guys is very good. And these are the types of issues that the Supreme Court is ultimately going to need to weigh in on. I mean, I think that these are the right arguments. I think that if you just take their favored outcome and you just extrapolate that as a rule, and everybody can just charge a prosecutor, a politician, we go to a very bad place pretty quickly in this country, which is maybe where they want to take us. But the founders had some logic on this, right? We wanted to deal with our political prosecutions politically. Trump made a political statement about a political election. It was resolved politically in Congress. He was acquitted of that. And now they're trying to do it again. So that, I think, is really where the fractures to our country and to our government come into play. It's much more serious than anything Trump has done. And so we're going to continue to go through these motions. We've got a lot more to get to. We'll come back and hit the motion to dismiss on statutory grounds from Donald Trump as we go through the mother lode of the motions to dismiss and other filings. So please make sure you're subscribed, my friends. Invite a friend or family member, somebody you know or love, to come and join us, because this case is just heating up. We've been waiting for this document drop, and it is here. And so we're going to continue to cover this case and all of the other Trump sagas, including where we're going to go next, which is over to New York City. And so we'll look forward to seeing you on the next one. All right, my friends. Now, let's see what's happening inside the courtroom with Michael Cohen. You remember this guy. Convicted perjurer Michael Cohen testified against Trump in Big Tishy James's trial that is taking place in Judge Engoron's courtroom. And we know that convicted perjurer Michael Cohen's not a very reliable guy, because we've talked about, well, his plea deal where he actually was convicted for perjury. But he was the subject of today's trial. He testified for quite a bit. We're going to see what he had to say about it. Of course, he will be subject to cross-examination from Trump's defense, and they're going to make a field day of this one because he is a liar, in my opinion. But this is what the conviction or the plea deal looked like before we see what was happening in the courtroom. Trump had a short couple statements, and then we'll jump into the trial activities. But as a reminder, we know that Michael Cohen, in fact, pled guilty. And here is what it looked like. This was the document signed by him in the case involving United States versus Michael Cohen from the special counsel's office, drafted 2018 in November. All the way down here at the bottom of this agreement, you see, oh, Michael Cohen's name right there. Says here, I read every page of this agreement. I've discussed it. I fully understand this agreement. I entered voluntarily of my own will. I'm pleading guilty because I am in fact guilty of the offense identified in the agreement. What offense is that, do you wonder? Well, pretty simple. Right here it is. Michael Cohen saying that you have agreed to plead guilty to a criminal information charging your client with making false statements to the United States Congress, lying to Congress in violation of 18 U.S. Code Section 1001. So Michael Cohen, a convicted perjurer who entered a plea deal agreeing that he is actually a perjurer. And this is actually a real plea deal, okay, with an actual conviction. Unlike Fani's cases, which are not actual convictions at all, not even actual guilty plea judgments, as we'll get to. But a convicted perjurer showed up in court today. A lot of people on the left love this guy for some reason. I don't know what it is about him. Maybe it's the accent or something, but he showed up in court. People are thrilled. I think because they know that he'll lie to get rid of somebody that they don't like all that much.
Michael, come on, you're lying.
Here, Michael.
All right, so he's in court. You can see the cameras not really making their way inside. We got a couple clips from Trump before we see what took place in trial today. Trump came in after the fact and they asked him, hey, Cohen's going to be here. He's testifying today. Tishy's in the courtroom, sitting in the back of the courtroom, not actually doing anything on the attorney's table. But here's Trump coming in and he gets asked about Cohen.
How do you feel about Jenna Ellis taking a plea deal?
I don't feel to see Michael Cohen here.
We haven't seen him in years, and you know his record. His record is a horrible one. All you have to do is ask the Southern District of New York. He's got a horrible record, but they're just starting, but you'll see how it ends up.
What about his
It's not going to end up very good.
What about his testimony?
We're not worried at all about his testimony.
Not worried at all about his testimony. You know him. He's a liar. He's a perjurer. Just ask the Southern District of New York, which I think is maybe where that plea deal came from. But Trump was also taking a break, and this is what it sounded like when he was talking about the judge. And there was also a little bit of a COVID issue because in New York, they're still, I don't know what they're doing there, but I don't think really many people know what they're doing there. But there was a COVID issue. Trump said, well, actually, the trial was delayed yesterday. They were supposed to be in court yesterday, but it got bumped because of some COVID thing. And apparently it's all cured now or whatever. So they're back in business. And here's what Trump said.
Concern of COVID in the courtroom?
We'll be out later. No, they should not have done that. What they did with COVID in the courtroom was a disgrace, and they should apologize. They should not have done it. And except for the bias of the judge, he should have held it off a little bit. But we're winning this case, other than the fact I don't have a jury. And I want a jury. We're entitled to a jury. Thank you.
All right, so a couple short statements from the president, and he is in court. And so let's take a look at who is doing the reporting there from inside the courtroom. This is Adam Klasfeld. He's reporting over now for The Messenger. And I encourage you to give him a follow. He does good legal reporting. And he's at Klasfeld Reports on Twitter. And so he's in the courtroom. People are filling in. We have New York State Attorney General Tish James. She enters the courtroom and she sits in her usual spot right in the front row in the back of the courtroom. And she lets all the other attorneys do all that actual work. But Klasfeld is in there. Now Trump's lawyer, Christopher Keese, comes in. Apparently he's talking with Tish. He's like, yeah, what up, Tish? So Trump enters next, walks slowly to the defense table, flanked by his attorneys, Chris Keese and Alina Abba. I wonder if she's wearing a turtleneck today. All rise. Oh, crap. All right, judge is here. All right, please be seated. All right, proceedings are going to begin soon. Photographers are in there. Before the trial begins, Trump's defense comes in. Your Honor, before we begin, can I please address the court? Oh, gosh. What, Chris? Yes, go. Your Honor, Tish is being irresponsible in convening a trial today after Monday was adjourned because of a COVID scare. I can't believe we're here today. Chris Keese says it was members of her office that tested positive. Oh, no. Oh, no. Tish's office. Man, I wonder what their jab policy is there. That's weird. I wonder what their policy was on that one. Somebody got COVID. Maybe they didn't put their mask on. So they have an infection, and it's just spreading around their disgusting office. And they have to adjourn a trial on Monday. And so they're like, well, we got to come back on Tuesday. And Trump's people are like, gross. We're healthy, man. We don't want to be around these little disgusting people. So Keith said, it's very strange here, Your Honor. Here we are trying to be responsible and abide by COVID protocols, okay? We should at least be out of here for 2 weeks. What does the CDC say? Go check the protocols. And this is very performative from the defense, which I love, by the way. Like, absolutely. If you want more time, like, you got to make a mountain out of every single molehill. So absolutely, I'd be throwing my fists up. I can't believe this, Your Honor. I got a family. I got kids at home, man. It means I have to go find some kids, or have them quickly. But you get the point. It says it seems that nothing else matters except for pursuing President Trump. We're in here, we're all going to die thanks to Tish. So then Tish's lawyer, okay, not even Tish herself, she says, I take exception to you calling us dirty over here. And how dare you claim that we were irresponsible? We wear our masks. Do you? So this lawyer's like, we're also following the CDC guidelines. Well, I don't know what to tell you about that. Well, how come you caught COVID then? I don't know. So Engeron is saying, what he said, the judge says, well, masks are available. Okay, so he tells Trump's people, we're going to let these sick people infect you from across the aisle in this courtroom. He says, Chris and Trump, why don't you just put your masks on? Okay, masks are available. I'm going to proceed. I'm like, oh, great. We're all going to die now. Hopefully you're aware of that, everybody in the courtroom. The government's going to kill you just to prosecute Trump. You know, I'm not making any medical claims here, okay? I'm being facetious. This is satire. Gosh. And says none of the defense attorneys is wearing a mask, though one from the AG's office is. Well, I wonder who that is. All right, so you get the picture. Here, it's just hilarious. So none of the attorneys took the judge up on the offer. Well, why would they? What the hell's the point? This is not medical advice, but why would they put a mask on? The hell's the point? All right, so neither did Trump. Okay, obviously. Nobody masks up, but they have a fight over the mask. So all right, yeah, okay, so COVID's over. All right, up now, Bill Kelly. So we don't have Michael Cohen up yet, but he's going to jump on soon. So, Your Honor, the government now calls Bill Kelly, you know, all the COVID-exposed government is now going to be here testifying. So they call Bill Kelly. Bill Kelly comes up. Bill Kelly, they say, can you tell us about this document? He's reviewing it. And oh, yeah, I remember that. It's from May 18, 2021. Well, what is it? He says it's a letter to Alan Garten. What were you doing in the letter? He says, I was resigning. Resigning? What does it say? I was resigning from all engagements with the Trump organization and all the related entities. So the witness now reviews the letter. Oh, you resigned? Oh my gosh, why? Why did you resign? He said, well, I resigned because Trump's statements of financial condition from 2011 through 2020, he said, should no longer be relied upon. We write to advise, this guy's writing via email to the Trump organization. Witness now reviews this letter. It's a letter to Alan Garten. I don't know who it's from. Dear Alan, we write to advise that the statements of Trump for the years of this time should no longer be relied on and should inform the recipients of those they should not be relied on. We've come to the conclusion in part based on filings made by the Attorney General. Okay. Now, while we have not concluded that the various financial statements made as a whole contain discrepancies based on the totality, we believe our advice is no longer good. So here's the full letter. And this was signed by the witness. So this is curious. So Faherty, the affirmation. So this is a letter, Dear Alan, to Alan from the Trump organization, signed by William J. Kelly, who is on the stand. And he says, the due date to file those returns, okay, so you can't trust the numbers anymore. And what this reads like to me is that he's making this known because Tish filed the suit. Is that wrong? We've reached the point, here's what he says. While we have not concluded that the various financial statements contain discrepancies as a whole, okay, which to me reads like the documents are great, but we, based upon filings made by Tish and our own investigation and external sources, we've come to the conclusion that you can't rely upon those. So here's my point. If you took Tish out of here, if Tish wasn't breathing down Will Kelly's neck to say Trump is in disarray, would he have submitted this at all? He says, we have not concluded about that these statements have discrepancies, but Tish, based on the totality of them, is saying that they are. All right. So he's on the stand. And he says, yeah, that's it. I guess he's brought in to introduce that statement. Okay. Which doesn't seem that bad at all to me. Okay. So cross-examination begins. His co-counsel shows up. Trump's lawyer, his name is Jesus. Shout out to Jesus Suarez. So his counsel returns to the COVID issue again. He says, Your Honor, can we have another microphone here that's not been breathed on by these disgusting government bureaucrats, please? Get them out of here. Put a face shield up. Hey, government. Hey, bailiff, can you go get some of your plastic shields out of the closet that you had and just wrap them around the government and Tish's head, please? It's for COVID, man. It's for safety. So they ask for another microphone or a cover to avoid contamination. Ugh, gross. But one isn't available. Oh, I don't know why they don't have those things. Again, none of them is wearing a mask. Of course not. So Suarez is underway. Cross-examination starts. He says, all right, Mr. Kelly, now you were asked by the New York Attorney General to testify in this case at the end of the last summer. Is that right? I don't know when it was. I think it was several months ago. When were you subpoenaed? I don't know. Have you seen a subpoena? I think I have. Okay. So you have no specific memory of getting a subpoena at all? No. Okay, well, I think that you were deposed. You had a deposition. You remember that? Yeah. Remember where that happened? Yeah. I think that was Trump Tower. And so when you were there, you agree that you discussed their testimony, right? We talked about your testimony, right? Yeah. And you practiced for your direct examination today, didn't you? Objection from Tish in her plastic box. Says, objection, Kelly previously disputed the characterization of it as practicing. Don't call it, okay, say it again. So you also told me that you had no concern with the work Donald Bender did for Trump, right? You said that his work was fine, right? Correct. And so he's now trying to undermine that guy's credibility. He says at some point you disagreed with Bender, didn't you? Well, I may not have read every line, he says, but I did look at it. Bender said at the time that, quote, I may not have read every line, but I did look at it. He says, does that testimony concern you at all? He says, no. So he says, I want you to review this statement of financial condition from 2014. I want to show you this document. See it? Yeah. Now, I want to draw your attention to a passage here on the value of the Trump brand. Do you see that? Yeah. Can you read that for us? He says, sure. He says, it says here at the end, the goodwill attached to the Trump name has significant value that has not been reflected in the preparation of this financial statement. Now, the goodwill attached to the Trump name has significant value that has not been reflected in the preparation of this statement. That's on the document. Now, Klasfeld tells us that the judge found this language was fraudulent because Trump org was boosting assets from brand value, is what I think that's Klasfeld inserting. In other words, I don't think that that happened right now in sequence. So he says, Mazar's witnesses have emphasized that they provide compilations, not appraisals, and the distinction being that they are not responsible for the underlying data. So, well, I don't know what they said, but we're not responsible for that. So then he seeks to undermine that argument. He says, well, how about this? In 2017, the Trump organization was forced to change the size of the triplex, Trump's New York's triplex. Forbes publicly confirmed apparently he lied about the penthouse. Now, Mazars didn't repudiate the financial statements until years later. So he alludes to that in his questioning. So they break for the morning. Now, maybe not yet, but he says Kelly testified that Mazars, this other organization, cut ties with the Trump organization because they doubted the credibility of Alan Weisselberg, who would also later be convicted. Trump sitting there, he's watching the testimony, leaning back in his chair, facing the witness stand, head slightly tilted back, occasionally turning his head towards his lawyer. Now we get a morning recess and they take a break. Klasfeld's reporting, coming back soon. Trump's back in the courtroom. Eric Trump's there, his son, sitting in the front row opposite Tish. Cross-examination continues. Judge yells at Trump's defense, hey, stop repeating your questions. And Trump's lawyer jumps up and says, hey, Judge, how are you criticizing our team? This never happens during their examination. Okay, they repeat questions over and over. You're not scolding them. The judge is sitting there chuckling. We just disagree on what the reason is. He knows nobody, it's his courtroom. Who cares? So Suarez ends his questioning by claiming that Bender buckled to harassment from Tish. He says it was harassment. He lost his biggest client. He went to the White House and cried. And he cuts him off. Is this a speech or a question? Trump's defense. He alludes to Kelly's letter. He says, we have not concluded that the various financial statements as a whole contain discrepancies, right? The exact line that we just parsed out. And he lauds the witness for having the fortitude to resist the harassment. So, Kelly's done. Now, entering the courtroom, today's big witness, Michael Cohen, convicted perjurer. Weakling, pathetic, no eye contact with Trump. Walks in right by him. He's like this, Michael Cohen. Don't look at Trump. Walks right by him. Pfft, pathetic. You walk in and you make eye contact directly. And you look at somebody closely. And you say, watch this, buddy. That's how you do it. But that's not what he did. So he walks on by like a little perjurer and walks right to the stand, ready to lie. In my opinion, we'll see. He says Cohen begins with his educational background and his prior convictions. So why is Tish bringing on a perjurer to testify? Well, there's no jury here, so the judge is just going to believe whatever he wants to believe. So including Trump-related campaign violations and lying to Congress about Trump's business interests, right? The guy's a liar. But they always, you see how they always include Trump in there, it's always Trump. So far, Cohen delved into the statute rather than the background details for whatever reason. They say, hey, Michael, this is Tishy prosecutor up there. Obviously not Tish because she doesn't do anything in this case other than just sit there and observe like an intern. Says, asked whether he made a public comment on this. Hey, Michael, this is the Trump case. Have you ever talked about this case in public? He says, yeah, on more than one occasion. And you've been convicted of other crimes. You want to clarify anything about that? He says, yeah, I acknowledge my complicity in the Stormy Daniels matter, though he said he wasn't implicated in the hush money payments. He says that he says, I told lies about Trump Tower and Moscow at the direction of, in concert with, and for the benefit of Mr. Trump. Right? He's probably not looking at Trump either because he's a weakling. He said, Christopher Keese moves to strike. He says, that's not responsive, Your Honor. He says, I don't know if that's from a book that he's writing or what, says Trump's lawyer. Judge says, oh, quiet down, Chris. Overruled. He says, well, the question could have been shortened, but it was responsive. So he's kind of giving a nudge over to Cohen. Hey, just answer. Just answer. Okay, don't make your little stupid speeches. So then Cohen, they ask him about, well, tell me how you came about your initial business connections to Donald Trump, Michael. Prosecutor says. And I keep saying prosecutor because that's essentially what this is. Okay, it's a civil prosecution, even though it's not a criminal case. It's a civil case, but these are Tish's Attorney General's office. So I says, prosecutor to Trump says, or to Cohen. He says, well, how did you come across Trump? He says, I was asked to handle a few matters for Mr. Trump, which also resolved successfully. And he asked me if I would leave that sleepy old firm and join him. Now, who did you report to at the Trump organization, Michael? He says, Donald Trump. Anyone else? No. Now, Colleen Faherty hammers the point home with similar questions, same answers. You reported to Trump? Yeah. Anybody else? No. How often? Regularly. And anybody else there? No. And blah, blah, blah. And so anybody else before you talked to Trump? No. Always you? Yeah. Okay. Got it. Enough. Cohen, he says, my position was outside the legal department. He says, when I started, Jason Greenblatt was the general counsel alongside with George Ross. And they say, thanks for that. Now I want to ask about Trump Jr. They say Cohen is testifying about Trump's kids, Eric and Donald Jr. He describes Eric as being involved in development and acquisition of real estate. He says, he was pretty concentrated on golf as well. Again, different opportunities that would come into the company. Don and Eric and Ivanka, they would split different opportunities. And they said, I was involved in the potential acquisition of the Buffalo Bills, as well as the Miami Doral property. And they say, I want to show you some documents from June 2011. He says, all right. Does this appear to be a document that you may have worked on during your employment at the Trump organization? Cohen, not that bright, says, I don't recall. Well, they turn to another page and it's listing Trump's assets. They say, well, turn that page over. Hopefully you remember this one. Oh, tell me about this. And so we have this statement here. Cohen says, quote, this is a quote from Klasfeld. I was tasked by Mr. Trump to increase the total assets based upon a number that Trump arbitrarily elected. And just by the way, this is a convicted perjurer liar who is saying this here, so whatever. And my responsibility, along with Alan Weisselberg predominantly, was to reverse engineer the various asset classes, increase those assets to achieve the number that Mr. Trump asked us. What number did Trump ask you to do? Well, it doesn't, I don't know. He says, whatever Mr. Trump told us to do. And so, okay, that's a liar who's making that statement. So take it for what it's worth. Now, the judge is going to say, wow, that's incredible. That's amazing, Michael. Thank you for your honesty here today. But now we're back in session. They took looks like a lunch break. They say, let's keep going there, Michael. Now, tell me about your work with Alan Weisselberg. He says, well, it's pretty easy. We would look at the assets. We would increase its values in order to achieve the number. So me and another guy, Alan, would collude to increase our asset value. They say, did Trump ever say anything to you? And he said, oh, yeah, all the time. What did he say? Give me an example. Donald Trump told me, he said something like this, I'm not worth $4.5 billion. I'm really worth more like $6 billion. Now, Cohen has shown some documents. You see here a bunch of math adding up, 4.597 billion. No, that's million dollars total assets. Oh, that's probably no, that is billion. I'm sorry. I thought it was 0.00. That is billion. Okay, so 4.597 billion. Now, Cohen testifies that he understood that Trump said it's more than that. And here, Cohen, he says that he understood that Eric, Don Jr., and Ivanka were involved in valuing properties. So the judge asks the question, did you see the children involved? And Cohen says, no, I didn't. I did not personally observe that. So what types of things did Donald Trump inflate, liar Cohen? He says, quote, possibly Trump Tower, Trump Park Avenue, Trump World Tower, 100 Central Park South, mansions at the Seven Springs, Miss Universe pageants, and other assets, right? They're all listed here. So then the testimony turns over to the Gang of Four. And this is apparently a quartet called Matthew Allen Weisselberg, Ron Lieberman, and him. They say that they all did stuff together. They talk about the Buffalo Bills. They ask a question about the Buffalo Bills. Cohen says, we had a meeting in Trump's office with members of the DB's team to secure a loan that would be predicated off of his assets to get the bills. Now they go through another email. It's a message from Ivanka to somebody else. Keese is objecting. He's standing up. Your Honor, what is this drive-by reference to the Buffalo Bills in the lawsuit? You can't just bring that in. And Engeron actually goes over and says, we don't need to get into all this. I believe we can all agree that Trump never owned the Buffalo Bills. Tish's team says, yeah. So the judge just admits it in. Now, no direct eye contact between Trump or Cohen since they shared a physical location for the first time in half a decade. But now we're back. Cohen's examining a piece of evidence related to the Buffalo Bills. And the letter says that I have a net worth in excess of $8 billion. Financial statements to be provided upon request, comprised of substantial cash balances, highly liquid assets, and very little debt. Now they say, so, okay, he sends a letter, it's just wild. He says, I want to purchase in this letter the Buffalo Bills for $1 billion. I'm worth 8. Tish says, at the time, Trump was only worth 2.3. He lied in a bid that never ended up happening, and that's the big reveal? He made a letter to a Buffalo Bills bid and never got accepted, never went anywhere? Okay. So they say no further questions. We're like, wow, that's your big reveal. Good job, guys. So then we get back out now. It's cross-examination time. And guess who's up? It's Alina Abba in the house. And man, this is probably going to be the best cross-examination you've ever heard, ever. So just be forewarned, because she's a great attorney. Alina Abba comes up to the stand. Mic's not working. Things, tripping out in the courtroom, all over the place. Somebody tells her, you should just speak up. Alina, sharp as a tack, says, that's the first time someone told me to speak louder. Heyo. Alina walks up to the podium. She's not afraid of eye contact. She looks Cohen dead-eye. Hello, Mr. Cohen. Miss Abba? What would you like me to call you today, Mr. Cohen? He says, I think Mr. Cohen for today would be good. Mr. Cohen, do you have any health issues at this moment that would prevent you from answering fully and honestly? Cohen objects, asked and answered. He's objecting to her. And Alina says, that's not your job here. That's their job. The Attorney General does the objecting here today, Michael. Mr. Cohen, thanks. He says, no, I'm not. Under the influence. Nothing will prevent me. She gets control of the witness. Beautiful. Now, Mr. Cohen, you understand what under oath means, right, Mr. Cohen? Yes. Well, that's good, because you took a guilty plea under oath. I want to show you this one from 2018, where you took guilty pleas for tax evasion. You remember that? He looks at her, yeah. And these charges were not related to Donald Trump, were they? No. Now, he's objecting. And Adam says he's not allowed to do that. He's the witness. And so this is turning into just madness, okay? He's objecting. He's throwing a big fit. You've heard Michael Cohen. He just talks strangely like he's got marbles in his mouth. And he's just throwing a fit on there. And Christopher Keese now from Trump's defense jumps up. Your Honor, this witness is completely out of control. Why is he objecting to Alina Abba's most perfect and beautiful questions? So something happens. They get it under control. Alaba gets back on the podium. Now, you're not on a mea culpa, okay? You're not on mea culpa, Mr. Cohen. You're not on your podcast, okay? You're not on CNN, says Alina. Now, after a question's asked about whether he still has his law license, you don't even have your law license, do you there, Michael? Cohen also says, asked and answered. And that's the day. Trial ends for the day after it's noted that it's not his objection to make. Your Honor, he's a witness. He's not a government prosecutor. Testy cross-examination will resume back on Wednesday. And my goodness, my friends, I've not heard a cross-examination quite so incredible. Amazing job, Alina. Really amazing. You're awesome. So that was a great exchange there. Michael Cohen in court testifying about Donald Trump. And so he's a convicted perjurer, obviously a liar. And they brought him in here to talk about the Buffalo Bills and a Buffalo Bills letter that never went anywhere. So incredible job there, Tish. Now, we will continue to cover this, my friends. Thank you for subscribing and hitting the like button. Thank you for going to robertgouveia.com to sign up for our daily newsletter so that you get all of these stories, reports delivered to your inbox. And we'll look forward to seeing you on the next one. Now, we finally get to the big one on the day. And this one is going to be good because we've got some more documents that we have been waiting for quite some time. And now we are going to get to go through them. And it's involving Fani, which we've been dealing with a lot, unfortunately. Fani Willis loses another one. Her record is now 0-4. 0 convictions, 0 guilty judgments, and 4 people who are going to have their cases ultimately dismissed so long as they comply with probation and the other terms. Now, this is what we can call traffic school plea deals. Just like when you get a speeding ticket, you sign up for the class, you admit you did something wrong, you take the class, everything goes away, right? You've got no conviction at all. In fact, this is even more beneficial than those because these will be totally sealed, and by the judge's own order, we can say legally that the defendants have been totally exonerated under the law. Now, we're going to go through this. We've gone through 2 other change of plea proceedings, and today we're going to go through a 3rd one. This one is Jenna Ellis. And as we've been exploring these in turn, we've already covered Kenneth Chesebro, and we've also covered Sidney Powell's. We've been sort of playing the game from afar, watching these court proceedings and trying to speculate on what the documents look like that the judge is signing. And now we have the actual documents, okay? The judge has released them, and it is 100%, in my opinion, a deferred adjudication agreement, okay? It's even more beneficial for these defendants than you even thought. And so it's going to result for all 4 of them, as long as they comply, in nothing, total exoneration. And so we're going to go through it today in detail and refresh our recollection on what the code looks like before we attend to the actual change of plea proceeding with Jenna Ellis so we can see exactly how all of this works. But let's start by going through the actual deferred adjudication document that came out from Sidney Powell. So we're going to see what Jenna Ellis goes through, but this is the form that is ultimately going to be released when her case gets there, okay? After it hits the court docket, we'll see something very similar to this. But I want to explain why this means that Sidney Powell's case is going to be going away and why Jenna Ellis's is very similar. And so let me see, did I not pull that one up? Oh, here it is. Let's see. Oh, wait a minute. I did not pull it up. Okay, so let me grab that real quick. These are Sidney Powell's first offender terms. And this is what the judge entered behind the scenes. Okay, this got entered a couple days after Sidney Powell's plea deal was accepted. This is the final disposition. And if you take a look at this closely, it's OCGA 428-60. This is the first offender conditional discharge deal. It is a plea deal that is going to result in a deferment of the guilty plea, meaning they are not going to enter the guilty plea as judgment in this case. And as long as everything's completed, it will result in a dismissal. I'll show you exactly what it means and how this works. See, each one of these is a disposition. You could have a disposition of guilty or not guilty. You could have an Alford plea, right? A no contest plea. But they have the disposition of this case not as a guilty plea, okay? You don't see guilt anywhere. That is the conclusion of the case. It is an option, but it's not applied here. Instead, they have this separate carve-out where you go into this suspended prosecution mode. They take your guilty plea and they just hold it, okay? They just put it on an audio recording. They take all the paperwork. They just put it on a bookshelf and they wait. And they put you in this first offender status. So Fani has not secured for this case a guilty plea at all. The disposition status of this case is first offender status. And it's for all 6 counts, as you can see, that she pled guilty to. Went through a guilty plea proceeding for, but has not been adjudicated guilty for. And I know this is very nuanced, but we're going to get there. You see, this was signed off on in the case of Sidney Powell, entered 10/20 into the court in Fulton County Superior Court. And here's what the judge wrote on here. And this is Judge McAfee signing this, so you can see his signature right down here. Entered into the record on the 19th day of October, 2023. And this is for Sidney Powell, arguably the mastermind, the person with the kraken, the person who was one of the most outspoken people that we saw. This is her sentence. It's called deferred adjudication. That is the disposition. First offender deferred adjudication. They say the defendant is sentenced under first offender for these offenses, all 6 of them. This is the same pattern that we're going to see for Ellis and Chesebro and Scott Hall. The court sentences the defendant to confinement in an institution as computed by law. But that institution, right, it can be like the Department of Probation. So it doesn't mean you're going into confinement. You're just now under the jurisdiction of the probation department. Here's the sentence summary. Sidney is sentenced for 72 months to be served on probation. Now, they tell us that the above sentence may be served on probation, provided that they shall comply with the terms of the condition here. And we know what these are because we listened to the whole plea agreement. Don't break the law. All right, going to do that anyways. Avoid injurious and vicious habits. Avoid places of disreputable harm. Report to the probation officer. Work a job. Don't change your place of abode without notifying us. Support your legal dependents. It's like all good behavior. Make restitution as ordered by the court and complete evaluations when ordered by probation. The court also orders a fine. We know these fines, $2,700 in restitution, apology letter, testify truthfully, which he was already going to do, and shall have no communication with co-defendants. And she must do a full recorded proffer with the state and give any documents absent the lawful privileges prior to entering the plea, which is fine. She gave him a bunch of stuff. That's no problem because they didn't break the law. But here is the big paragraph. Now listen to this. This is going to apply to Ellis and this is going to apply to everybody that we've covered here. First offender or conditional discharge, and this is for Sidney Powell, says the defendant, Sidney, consenting here too, agreeing with this, it is the judgment of the court that no judgment of guilt be imposed at this time. So Fani's guilty pleas are not even really guilty plea judgments, okay? They're guilty pleas that are just held in this state of abeyance, this suspended state. They're just going to be closed and put on a bookshelf. So no judgment of guilt be imposed at this time, but that further proceedings are deferred. It's a deferred adjudication. So everything is suspended, and that Sidney is hereby sentenced to confinement, which is going to be with the state, which is going to be probation, as computed above, 6 years. Now, upon violation of probation terms, so if she commits another crime or if they determine that she was a felon, they didn't tell her about, the court about, then the court can take that guilty plea and just enter it, okay? At that point, if they fail, then they may enter an adjudication of guilt at that point and proceed to a sentence. But that has not happened yet. But upon fulfillment of the terms of this sentence, or upon release of the defendant by the court, so the court can terminate this early, the defendant, Sidney Powell, and this same language is going to apply for the defendant, Chesebro, the defendant, Hall, the defendant that we're covering today, which is Jenna Ellis. Oh my gosh, my brain just dumped right there. All of them, Jenna Ellis, Sidney Powell, Scott Hall, and Chesebro, shall stand discharged of the said offense without court adjudication of guilt, no adjudication of guilt, and shall be completely exonerated of guilt of the said offense charged. Oh man, they hate that. Fani hates that. Did you hear that? Shall be completely exonerated of guilt of the said offense charged. Oh man, that's terrible. If I was a prosecutor and I got 4 of these so-called insurrectionists who led the biggest attack on American democracy since the Civil War, blah, 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 if I got all dressed up for a press conference out there, put on a suit and tie and everything, and the 4 case dispos that I have are all first offender acts that result in no jail time, no judgment of guilt, no criminal conviction. The cases are going to be sealed, and they're going to be considered under Georgia law, literally completely exonerated of guilt of the said offense charged. What? This was signed off on by the judge, Scott McAfee. I've read the terms of the plea, and of course, all entered. Now, Sidney Powell got this term. This was filed on the Georgia docket. This is the First Offender Act. Okay, and this is the same thing that we were speculating that it was. It says that it is before an adjudication of guilt. This is what the actual law says. Here, that upon a guilty verdict or plea of guilt and before an adjudication of guilt, the judge, without entering a judgment of guilt and with the consent, may defer the further proceedings. And they may do that, and they deferred it. Okay, so none of these people have been convicted of anything. And, arguably, they haven't even, you can say that they entered a guilty plea. I think that's fair because they did do the guilty plea proceeding. That is true. But they did not become adjudicated guilty. Okay, the judge just took that and they're just holding on to it. And if they fail, then they will be found guilty. But this is the same thing that happens in diversion agreements all around this country. It's like first offense shoplifting. You get a first offense domestic violence charge in many parts of this country. You get a speeding ticket, a traffic ticket. You do something, in exchange for doing something, everything goes away. That's the whole point of the First Offender Act. It's to make people not overly oppressed from the criminal court and the criminal justice system. Now, I think it's an amazing thing that these programs exist because it does give people an opportunity to get things back on track. But it's amazing that Fani would be offering this to 4 of the most heinous criminals, allegedly, in America. So my point is, all of these people took really incredible deals, like incredible. Like their charges are going away like it was a first offense urinating in public somewhere, okay? It's crazy. And Fani is now 0 and 4. So every time you hear this stuff in the media that, this is all doom and gloom for Trump, it could be. Like they could all flip and all start turning around and, blaming him. That's all true. But at this moment, Fani's case is so weak, she couldn't even leverage criminal prosecutions for 4 of the biggest people involved in the case. We'll see what happens with Rudy and the other people, but I thought Sidney and Jenna, 2 of the 3 there are 2 on the top row on this tic-tac-toe board, and both of them are going to end up with no convictions at all, provided they comply with the terms of probation. So we're going to jump into the plea deal here in a quick second. I just wanted to show you what the documents look like. Aiding and abetting, false statements in writing. So Jenna Ellis is the person who is the latest to go through this traffic school plea deal process. And hers is a little bit different because she does give us a statement, which I don't know how necessary it was, but we'll see what the proceeding has. But Fani signed this one. Okay, so she's signing off on all of these First Offender Act deals. And here saying that she's going to agree to the following, saying that they made false statements to member of the Georgia Senate, saying the following numbers, right? I'm not going to read through all the numbers, but saying that these statements were illegal. You made false statements to the Senate and those things were illegal. Fani Willis, very upset about it, but not that upset about it because the case is going to be dismissed, as we'll see in the proceeding. Now, this was the waiver of the indictment, so they brought a new charge against her for this new crime. And so Jenna Ellis signed off on this, saying that she agrees to waive the indictment by a grand jury. And so without any further ado, let's show exactly how this works, because you're going to see it happen once again in the court in Judge McAfee's proceeding.
Sufficient factual basis for the...
And let's get this puppy queued up and ready to go. Big Fani's courtroom. We've got the usual faces here. The judge has not taken the bench quite yet. Nope, not quite yet.
Partner.
Oh, there you kiss. All rise.
947
Now we're on the
State
record.
versus Jenna Ellis. We have the state here present in court today, as well as Miss Ellis and her attorney. And just for the record, sir, if you could identify yourself.
Yes, thank you, Your Honor. I'm Franklin Hogue. He is my law partner and wife, Laura Hogue, and we represent Jenna Ellis.
Good morning, Your Honor.
Good morning, y'all. So collective welcome to the Hogues.
Thank you, sir.
And I understand that we've again been requested to schedule an impromptu hearing on a change of plea. Is that correct, Mr. Wade?
It is correct, Judge.
Just got it
And
worked
is
out.
Ms. Young taking the lead on this?
She is.
Yeah.
Judge, indeed.
Ms. Young,
And if all the terms, are there any other terms that we need to go over, or is
Nope.
everything agreed to between the parties?
Everything's agreed to and negotiated, Judge.
amazing. We've
All right,
already
well, if
done
that's
this
the
3
case,
times.
then why don't we
Let's go.
have Ms. Young come back up to a microphone, either at the jury box or in the witness stand, and we can go through the colloquy. Yes,
I
sir.
just want to point out that also, Ms. Ellis also has counsel out of state, Mr. Melito. He's present in the courtroom, and he wanted to get permission to come and have a seat at council table.
No, certainly. Sir, I think we also need you to spell your name for the record, just so we're clear.
Yes, Your Honor. It's Melito.
Okay, welcome. All right, then
Pretty
let's
simple.
get into it. Mr. Hoag, do you have a preference between the podium or at council's table?
You can just stay here if that's all right with your honor.
It sounds fine to me. All right, Ms. Young, whenever you're ready.
Ma'am, Ms. Ellis, can you please raise your right hand? Swear from the testimony you're about to give shall be the truth and the whole truth, so help you God.
I do.
And are you the Jenna Lynn Ellis that's named in accusation 23 SC 190514, charged with 1 count of aiding and abetting false statements in writing?
Yes, ma'am.
And is this your true and correct legal name?
Yes.
Are you under the influence of any drugs, alcohol, or medication today?
No.
Is there any medication that you should be taking that you have not taken today?
No.
How old are you and how far did you go in school?
38 years old, 39 on November 1st, so very soon. And I completed my Juris Doctor degree.
And are you able to read, write, and understand the English language?
Yes,
Have you gone over this accusation with your attorneys, Mr. and Mrs. Hoag?
I have.
Do you understand that you're charged with 1 count of aiding and abetting false statements in writings?
Yes,
Have you gone over the minimum and maximum sentence with your attorneys?
I have.
And do you understand that that carries a minimum penalty of 1 year to a maximum penalty of 5 years to serve?
Yes,
Do you understand that you have the right to plead guilty or not guilty to this charge? And if you plead not guilty, you have the right to remain silent and move forward with the jury trial.
yes,
Have you reviewed the waiver of rights with your attorneys?
I have.
And have you gone over that waiver of rights and also signed it
I-
along with your attorneys?
I have.
Have you had enough time to speak with your attorneys in regards to the facts in this case and any defenses that you may have if you were to have gone to trial?
Yes,
Do you need any more time to speak with them?
no,
And are you satisfied with their services?
very much.
Heck
Mr.
yeah.
Hoag, do you waive formal reading of the accusation against your client?
We do.
Do you waive any defects that might lay within the accusation?
We do.
Yeah.
Ms. Ellis, have you been arrested on these charges?
Yes,
And does the state's understand that there are no other outstanding related warrants to this charge? Do you know of any to your knowledge?
I do not.
Do you understand that this is a negotiated plea, which means the state and your attorneys have reached a recommendation to make to the court?
Yes,
Do you understand that the court is not bound by that recommendation and could sentence you to the maximum penalty for this charge?
yes,
Do you understand if the court does not follow the state's recommendation, then you can withdraw your guilty plea and move forward with the jury trial?
yes,
Do you understand that the conditions of this plea involves 5 years of probation, that you pay $5,000 of restitution to the Georgia Secretary of State within 30 days? And it's in my understanding that you're asking to be treated as a first offender.
Oh,
yes,
Do you understand that a special conditions of this probation is that you complete 100 hours of community service,
okay.
that you write an apology letter to the citizens of the state of Georgia, which you have already done, and the state will put that into evidence as State's Exhibit 1 for the court? That you testify truthfully at all hearings or trials
Had to do
involving
that anyways.
co-defendants, that you have no communication with co-defendants, witnesses, or the media until all cases have been closed.
yes,
That you must continue to provide additional recorded statements and affidavits to the state as required. That you must also continue to provide any requested documents or evidence subject to any lawful privileges asserted in good faith. That you shall not post anything on social media, including through any agents, about this case until the conclusion of all trials and appeals.
That's what they want, okay? They want you to not speak out about it. So we'll speak out about this. And listen, I know that there's a lot of trepidation out there. There's a lot of people who might watch, Jenna plead guilty or watch Sidney plead guilty and feel like it's a loss or something. And I totally understand that. But you have to think about the bigger context of this, right? These charges are going away, and they are going to legally be able to say that they were exonerated under Georgia law. So you got to ask yourself, right? Is it worth just saying, I made a mistake of law, I made a mistake of fact, I'm a victim of political prosecution, so I'm just going to sit here in this illegitimate courtroom, I'll go through these motions, and your life will literally get back on track, right? I know there's a contingent and a percentage of the population that would not ever do that, right? Never admit to something like this. But I think for most people, this is such a good deal that you'd have to be kind of insane not to take it, because we know that in these political prosecutions, things can go the other way, and you can end up like the Proud Boys or the Oath Keepers, victims of political prosecutions that are going to be locked away for decades, presumably, unless Trump wins and pardons them all. But my point is, and shout out to those guys, right? Those guys are heroes who stood up for the right to a trial in a corrupt jurisdiction. And this is very much the same thing, but this deal is just so good. I mean, you'd have to be almost trying to make a point in not accepting this. And I am also of the mindset that you can accept a plea deal, and that doesn't necessarily mean that you're going to turn on the bigger fish. Now, we'll see. Jenna's going to make a statement here that I've not listened to yet, but we're going to hear what she has to say.
That you must continue to fully cooperate with prosecutors, included but not limited to participating in interviews with prosecutors, appearing for evidentiary hearings, and assisting in pretrial matters.
Okay, so quick pause on this, by the way. Thank you for sharing this content. Okay, thank you for helping us spread this idea that these are not guilty plea judgments, because they're not. They are deferred adjudications. As we saw, the judge is not even accepting a guilty judgment at this moment. He's deferring it for a later date. So these defendants can't talk about this. Like, they can't defend themselves. They can't expose all of this. They're limited from communicating even the truth about their own deals. So you're going to see in the headlines, Jenna Ellis pleads guilty and she's going to turn on Trump and all those things. She might. I don't know. She might. But that's not what this hearing was. Okay. This hearing was a deferred adjudication, and her charges are going to be dismissed. So
You understand that these are the conditions of the recommendation that the state is making to the court.
I do.
It is my understanding that, have you gone over the first offender status with your attorneys?
I have.
And you're asking this court to be treated as a first offender?
Yes, ma'am.
Have you pled guilty or nolo to ever in this state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
And you've gone over the First Offender Act with your attorneys, and do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for this charge and the accusation?
I understand.
Do you understand that this guilty plea may be used to enhance sentencing of any other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand that you are being placed on probation and you cannot violate your probation by committing any other crimes in any governmental unit or violate any special conditions of your probation?
Yes.
Do you understand that if you violate the probation or any special conditions, that you will be subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess any or use any firearms while you're on probation?
she's got the firearm question just like Sidney had.
Yes.
Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation?
I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be if you were found guilty at trial? For example, your guilty plea may affect your right to vote, your right to hold office, your right to serve as a juror, the right to obtain a passport, the right to receive, possess, or transport a firearm, the ability to obtain employment, or your membership for the bar in this state or any other states.
I understand.
Do you understand that you are waiving all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, to the right to see, hear, and confront witnesses called to testify against you, the right to testify or remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a jury trial, the right to remain silent and not incriminate yourself, the right to confront witnesses, the right of the assistance of counsel hired by you or appointed by the court, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel production of evidence, the right to have the charges against you proven guilty beyond a reasonable doubt, and the right to appeal if convicted of these charges.
Yes.
Okay, so I have gone through this process probably over 100 times, and I'm not even joking with you on this, because in Arizona, we have something very similar to this for, well, it depends on the court, but for all sorts of different crimes. One of them is for criminal speeding, and you have deferred adjudication, but in the way that we did it in Scottsdale, in Arizona, is you pled guilty first. You go in, you do the guilty plea, but the judge holds off on entering the plea or on sentencing you. Okay, so the equation that I would give to clients is we want to avoid a conviction, okay? That is 1 + 1 = a conviction. We need two things. We need a guilty plea, we need a sentence, and then we'll have a conviction. But what's going to happen here is we're going to enter a guilty plea. We're going to go through the guilty plea proceeding, okay? So we're going to record it on the record. You're going to say that you're guilty. You're going to give up all your rights and all of the things, but the judge is just going to bottle that up and just put it on the shelf. And then once that period of time goes by, you are not going to be sentenced, okay? So 1 + 0 = no conviction. So we're just going to have this kind of temporary guilty plea, but eventually, once we fast forward through a couple months and you do your driving school class and you get your criminal ticket dismissed, we're going to take that guilty plea and just put it right in the shredder, and you're not going to have any conviction. It's literally the same process. Now, again, we didn't have allegedly criminal insurrectionists who were trying to steal American elections at my law firm at the time. They don't have them here either, evidently, which is why they're giving them this diversion deal. It's a deferred adjudication deal. But at this moment, okay, I've done this many, many times. And even though I've explained it to my clients many times, at this moment in these proceedings, people are freaking out in their chairs, okay? Now, Jenna's not, because she's a lawyer, and I'm sure she gets it. But people are still freaking out because as we're listening, it sounds like we're going through a guilty plea, right? Because we actually are. We're going through the proceeding, but it's not going to go anywhere. We're just recording it for the future case in case we need it. But then they're going to say, how do you plead? And guilty. And that doesn't mean that she's entered a judgment of anything because the judge is going to defer it. Listen.
Has anyone forced, threatened, promised, or coerced you in any way to enter into this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
It is.
How do you plead to aiding and abetting false statements and writings in under accusation 23 SC 190514?
Guilty.
And is this your signature along with Mr. Hoag's signature on the accusation?
It is.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you may have only limited rights to appeal this guilty plea?
I do.
And do you understand that you would have 4 years from today's date to file habeas corpus as in regards to this guilty plea?
Yes.
You're under the state, the accusation is signed guilty plea to enter.
Good question came up about her firearms. Now, she is agreeing to give up her firearms. Okay, the fact she is not a convicted felon, which is causing her to give up her firearms as part of the plea deal. They're just negotiating that away. They're saying, we're going to kind of give you some of the penalties of being a felon, but you're not obviously a felon.
According to the state's investigation, Ms. Ellis does not have any criminal history, so she would be eligible for first offender, which the state has no objection.
She's
to.
eligible.
All right,
Great.
before we get into a colloquy, I'd ask Mr. Hoag, if you could take back up the waiver form. There's actually a spot on here to circle about the first offender status. Right there.
Yes, sir.
Thank you, sir.
If this case had gone to trial, the state would have shown the following. On December 3rd of 2020, the defendant did appear before a meeting of a Georgia Senate Judiciary Subcommittee in Fulton County, Georgia, with co-defendants William Rudolph Lewis Giuliani,
Wow.
Ray Sterling Smith III, and other individuals associated with Donald J. Trump for President Incorporated, also known as the Trump Campaign. During the subcommittee meeting, Giuliani and Smith, acting as attorneys for the Trump campaign, made the following false statements. One, that at least 96,600 mail-in ballots were counted in the November 3rd, 2020 presidential election in Georgia, despite there being no record of those ballots having been returned to a county election office. Two, that 2,506 felons voted illegally in the November 3rd, 2020 presidential election in Georgia. Three, that 66,248 underage people illegally registered to vote before their 17th birthday prior to the November 3rd, 2020 presidential election in Georgia. Four, that at least 2,423 people voted in the November 3rd, 2020 presidential election in Georgia who were not listed as registered to vote. Five, that 1,043 people voted in the November 3rd, 2020 presidential election in Georgia who had illegally registered to vote using a post office box.
Okay, I want to pause on this very, very briefly because we caught something that she said in there that I may have skipped over. But this is what she's reading from, okay, this set of documents. And here is what she said. So just to be clear about this, so Jenna Ellis is not being charged with those things. She's with all the things she's reading, okay, this. She's being charged actually, which is kind of a lesser crime generally, with aiding and abetting. You see that? It's aiding and abetting Rudy and Ray. And then they went and they knowingly, willfully, unlawfully did the things. So if Rudy, right, so, you know, like if we're playing devil's advocate here and they're saying, well, they're just using all of these people to get someone else. Like Rudy, they better put him in prison for how long? You know, because he aided and abetted Rudy, right? So let's see what they get on Rudy. But this is everything that she's reading, and it's from the same new information. So this was the new document that they filed. This is not the old indictment, which had the other 19 co-defendants. That's what she's reading from.
Six, that 10,315 or more dead people voted in the November 3rd, 2020 presidential election in Georgia. And seven, that Fulton County election workers at State Farm Arena ordered a poll watcher and members of the media to leave the tabulation area on the night of November 3rd, 2020, and continue to operate after ordering everyone to leave. The false statements were within the jurisdiction of the Georgia Secretary of State and the Georgia Bureau of Investigations, who were each conducting investigations into allegations of fraud in the November 3rd, 2020 presidential election in Georgia. Once completed, these and others investigations affirmatively determined that there was no widespread fraud that could have affected the outcome of the 2020 presidential election in Georgia. The false statements were made with reckless disregard of the truth and with conspicuous purpose to avoid learning the truth. The defendant attended and abated Giuliani Smith in making these false statements by assisting with the execution of the December 3rd, 2020 Senate Judiciary Committee meeting that was held in Fulton County, Georgia. The false statements were used as part of a plan by the Trump campaign to solicit the Georgia General Assembly to disregard the certified results of the presidential election in this state and instead to unlawfully appoint non-elected presidential electors in violation of their oaths to the Georgia Constitution and to the United States Constitution. Similarly, false statements and solicitations were made to state legislators in Arizona, Michigan, and Pennsylvania, and the defendant was present and assisted with the execution of those meetings. And she was in attendance with Giuliani in Arizona and Michigan and Pennsylvania. That would be the factual basis in which the state would have proceeded on, Your Honor.
Okay, we got to be careful on this too, because if Jenna, okay, let's say that she turns on Trump and she shows up to testify against him, and she starts just running her mouth about Arizona and Michigan and all these other places, she could be charged there and for those crimes, and she could be charged federally, okay? So she's got exposure on that, and this deferred prosecution deal that is going to result in no conviction or guilty judgment doesn't grant immunity to the feds or to the other states. So they also have their self-interest at heart here to not just start testifying lest they be charged again.
All right, anything further from the state, Ms. Young?
Just that we filed a motion of null process and presented under the original indictment.
All right, turning to Mr. Hoag, just a few matters of housekeeping before I let you have the floor. If there's anything else you want to add, would you be requesting automatic sealing on this first offender
Of
disposition?
course.
Yes, that's one of my two notes here. to ask
And the other
court
one's
to
crime of
do
moral
that
turpitude.
Under 42-862-1B.
Yep.
please.
All right, and was part of this negotiated resolution, is there anything to note here about a behavioral incentive date?
Yes, Your Honor, that's going to be 3 years.
Mr. Hoag, is that right?
So all this can go away in 3 years, not 5.
That's correct, Your Honor.
And moral
Okay.
turpitude. Don't
Anything
forget.
else, Mr. Hoag, that you would like to add?
Moral turpitude.
Yes, if you could make a note that this is not a crime of moral turpitude,
Ah!
that assist us in other venues perhaps.
And is that an issue of negotiation between the parties? I know that has differed from resolution to resolution here. So where are we with that?
It is not, Judge. We're going to ask that the same verbiage that has been put on the other dispositions
Of
be
course.
put on this disposition as well,
Ah!
which I believe it says like the defense and the state have agreed that this is not a crime of moral turpitude.
Amazing.
Okay.
Get that language to Ms. Bordas.
So it's not even a crime of dishonesty.
So just to clarify, it's not a point of contention between the parties. It's being jointly recommended, this language?
No, it's stipulated. They
And is
agree.
that the case for, because I think we needed to enter amended sentences on the prior resolutions reflecting that. Is that the same for all 3 prior resolutions in this case?
That is correct, Your Honor.
Okay. All right, then if that is the joint recommendation, that'll be part of the global recommendation. Understood, Mr. Hoag.
Global
You know,
recommendation.
the only other thing is if the court is inclined to accept the negotiated plea, Ms. Ellis would like to exercise her right of allocution and make a brief statement to the court.
All right. So I think I would typically have that as part of the record before we finalize everything. So at this point, Ms. Ellis, you're not required to do so in any way.
That's right.
But
she's
if you
not.
would like to add anything to the record or address the court, you're certainly willing to do, able to do so. And now would be the appropriate time.
Okay, so the judge confirmed, okay, she is not required to do this. And we've listened to 3 other change of deferred adjudication proceedings here. One for Scott Hall. Actually, we didn't listen to that one here, but I did listen to it. And the other 2 that we did listen to here, Sidney Powell and Kenneth Chesebro, they didn't make any statements, okay? They just sat there with their hands in their pockets and they just let the whole thing go. Now, I would absolutely believe that Jenna Ellis didn't have to do this and same thing would have happened. But she might feel nervous, like the judge might not accept this deal or something like that. Obviously, I don't think that's the case. So I don't know that this was necessary at all. Let's listen to see what she says.
Now, if I may approach, I have it in writing what she's about to say.
I have one attached to State's Exhibit 1. Is that the same?
Oh, yeah, you have it already.
Okay. And so would the intention be that this also be going into the record as State's Exhibit 1, the written form? Okay. All right. Thank you, Mr. Hoag.
Thank you, Your Honor, for the opportunity to address the court. As an attorney who is also a Christian, I take my responsibilities as a lawyer very seriously, and I endeavor to be a person of sound moral and ethical character in all of my dealings. In the wake of the 2020 presidential election, I believed that challenging the results on behalf of President Trump should be pursued in a just and legal way. I endeavored to represent my client to the best of my ability. I relied on others, including lawyers with many more years of experience than I, to provide me with true and reliable information, especially since my role involved speaking to the media and to legislators in various states. What I did not do, but should have done, Your Honor, was to make sure that the facts the other lawyers alleged to be true were in fact true. In the frenetic pace of attempting to raise challenges to the election in several states, including Georgia, I failed to do my due diligence. I believe in and I value election integrity. If I knew then what I know now, I would have declined to represent Donald Trump in these post-election challenges.
Why?
I look back on this whole experience with deep remorse. For those failures of mine, Your Honor, I have taken responsibility already before the Colorado bar who censured me, and I now take responsibility before this court and apologize to the people of Georgia. Thank you.
All right. So listen, criminal proceedings are extremely stressful and extremely taxing. And I don't want to try to jump inside her mind. I always like to try to give people grace in these positions, of course, because it's really impossible to be in a position like this, right? It really is. And I've represented hundreds, thousands of people in criminal cases, and it is an impossible position to be in. So emotions are high. I certainly understand that, and we can pause and just make that note briefly. Simultaneously, I also don't think that that statement was necessary. I don't think she needed to read that. And so I don't know if that was intended to do something or not, right? I can't predict that either. But that statement was not necessary, in my opinion, legally. Like, you did not need to say that. That being said, it was a pretty traditional sentencing type of statement. I'm sorry, I didn't know. She was kind of deferring some responsibility in that. I actually don't think that that statement is that great, honestly. Like, if you're going to be there accepting responsibility in front of the court, what do? Is you accept responsibility. You don't say, I was just some dumb lawyer who was following more experienced attorneys out there. You just, look, I made a mistake. I made bad errors in judgment. Thank you, Your Honor. Next question. Or, I'm done with my statement. But she was making some things there that maybe you can infer are going after Powell a little bit or Giuliani a little bit. But I'm also trying to glean from this. Did she say anything in there that specifically targets Trump? That said that Trump ordered me to do something criminal? No. She said, I like election integrity. I was trying my best. She did say that I wouldn't work for Trump again, or I wouldn't do this again. But I think a lot of people would say that. And probably not because of the criminality that they were involved in, but because they've been prosecuted. I mean, there are tons of lawyers that would not touch Trump or his campaign with a 10-foot pole because of that, because they don't want to come under scrutiny from partisan hacks like Fani. So there's a lot here. Ultimately, I think this was unnecessary and honestly an error. It doesn't have much consequence to it, but we saw Sidney Powell didn't make a statement. She just sat there and the judge just let it go through. Same thing with Chesebro. He didn't say anything either. Okay, so it was unnecessary, which leads me to believe maybe there was more to the story. Maybe she wanted to make a point. Let's finish up.
And then thank you, Ms. Ellis, for sharing that. All too often.
Yeah.
I don't get to hear the perspective of the accused in this case, in these cases, and
Yeah.
so that's appreciated.
Thank you,
Yeah, because most people don't make statements during that time.
Your Honor.
Is there anything else, Mr. Hogue, that you would like to have as part of the record?
No, Your Honor.
Ms.
Okay.
Ellis, I have a few questions that I have to go over with you. Do you understand the nature of this charge that as it's been reaccused against you?
I do.
And you heard the rights that you would waive by going forward with this plea. Do you still wish to waive those rights?
Yes.
And are you pleading guilty today because you agree that there is a factual basis as outlined by the state to support this guilty plea?
I do.
Mr. Hogue, are you satisfied your client is competent and that this plea is understanding, voluntary, and that there is a sufficient factual basis to support it?
I am, Your Honor.
Ms. Ellis, do you have a weapons carry license of any kind in this state or any other?
I do not.
Well, I find that there is a sufficient factual basis for the charges, and I find that this plea of guilty is knowingly, voluntarily, and intelligently entered.
Okay.
Ms. Ellis, you've asked to be sentenced under the First Offender Act,
Boom.
which is a request that I will approve, and I'll
Boom.
withhold adjudication. But I do have to
Boom.
notify you that you
Did you hear that little phrase? Now they fast forward over this because they don't want to be articulate about this, but I will accept and enter your plea, but I will withhold adjudication. Meaning it's not going to get entered on the record, okay? It's going to be held in abeyance. Listen.
you can't withdraw. I will, Ms. Ellis, you've asked to be sentenced under the First Offender Act, which is a request that I will approve, and I'll withhold adjudication.
Ooh.
But I do have to notify you that you can't withdraw your plea simply because you don't abide by the terms of the sentence. And the terms of the sentence would be as negotiated and agreed to by both parties. On the sole count of aiding and abetting false statements and writings, the sentence would be 5 years probation. You're to pay a $5,000 fine to the Georgia Secretary of State's office within 30 days of the entry of the final disposition in this case. You're to complete 100 hours of community service. You are to cooperate with the state and testify truthfully in any further legal proceedings in this
Already
case.
going to do that anyways.
And you're not to have any contact, either personally or through other agents, with the media or any co-defendants or witnesses, I believe, in this case, as was outlined.
Yeah, that's because Jenna Ellis has a pretty big following out there, and they would hate it if she came out and told everybody that these are deferred adjudication plea proceedings. These are not guilty plea being entered as judgments at all.
We will include the language that is sent to us subsequently from Ms. Young, of course, with Mr. Hogue attached on that email to make sure that it is the exact language as agreed to by both parties. As requested by counsel, as a first offender sentence, this would be automatically sealed upon entry, and there'll be a behavioral incentive date of 3 years as well.
Automatically sealed.
I've been
not
provided
bad.
a motion to null pros the counts on the underlying indictment in 23 SC 188947, and I'm signing that now.
Sign it, Judge.
Is there anything else from the state that you believe we need to have on the record in this case?
No.
Judge, and if I misspoke, I said it should be a $5,000 restitution because the max fine is only $1,000.
Excuse me, that's right.
I may have missed.
No, that was my mistake. So it is a $5,000 restitution. I didn't hear a fine.
There is no fine, Judge.
Okay, understood.
Put it in the wrong box.
Anything
Just
else
put it
I
in the
need
right
to
box.
clarify or may have? Obviously, we will, as I mentioned, go off the language that were provided subsequent to this hearing. Anything else from the state, though?
No, Your Honor.
Okay, and Mr. Hogue, anything else we should have on the record? Take your time.
It's our understanding there won't be any travel restrictions as a part of her probation. I want to just make that clear, that there's no misunderstanding or dispute about that. She lives out of state.
No, understood. This is sometimes a challenge with out-of-state residents, that we have to have things transition and be moved to the out-of-state probation office, and they have to accept it as well. And so whatever we can do to facilitate that process, I would like to do. That may mean that if she has a flight today, I don't know if that's going to be possible.
All right, so they're going to work out the rest of the kinks, the mechanics there, but we get the gist of it. Okay, Jenna Ellis gets a deferred prosecution agreement. She goes through a guilty plea proceeding, but that guilty plea has not been entered as a judgment. And provided she completes her 3 years of probation, which will terminate early if she's compliant, which she will be, everything's going to go away. So Fani Willis is 0 and 4. She keeps losing. It's unbelievable that she would keep giving defendants involved in an American insurrection traffic school plea deals that'll all be dismissed later on down the road. My friends, we're going to continue to cover this case in depth. Thank you for joining us as we do. Thank you for subscribing. Thank you for inviting somebody to come over here and join us and watch as we uncover and expose the truth about what's happening in these proceedings. And we'll look forward to seeing you on the next one. All right, my friends. Well, we covered some good ground today. Fani loses again. She's not having a good time over there. She's really stinking up her courtroom. Cohen testified at trial, and he is, of course, as we know, a convicted perjurer. And we had a fun constitutional motion to dismiss that came out from the Trump camp that we covered at the start of the segment. But now, my friends, it is time to hear from you and to see what you have to say about this. Of course, if you want to become a member and join us for what's probably going to be a pretty short after party today, come and join us at watchingthewatchers.locals.com, where we do members-only streams in the morning. We do Saturday shows, and we have an awesome community there chatting away all the time. And Dolphin Fan is the man, is in the house. What's up, Dolphin? Bringing in 5 new membos in the house. Good to see you, Dolphin. Thank you for doing it, my friend. It's Taco Tuesday, by the way, in case you didn't know. Dolphin Fan is bringing in H8 SJWs in the house. Rose is here. Sup Forest is here. Marry Me and All Is One in the house, courtesy of Dolphin Fan is the man in the house. Big welcome to Troy Panetta as a supporter, joining us on YouTube. Don't forget to grab the Telegram link in the community tab section on the YouTube channel. We got Trump Gal for Life is over on Locals. Good to see you, Trump Gal for Life. Saying thanks, Robert. Prayers and America. God bless America. Thank you, Trump Gal, for the nice dono over on Locals. We got NY's here, says precisely because they're within the files of the DOJ, There was DOJ Office of Legal Counsel opinion that said a president could not be criminally tried. This indictment encompasses conduct while president. There are so many faults in the indictment. It is shameful. Kimberly Benedict is here, says, this morning's show was great. Thanks, Rob. Yeah, we had fun this morning. What were we doing this morning? It was mostly speaker stuff. We didn't really know what the heck was going on this morning. We're like, who's the speaker? No, it's Emmer. No, it's not. No, Donald's is out. No, this one's out. This guy's in. This guy's out. What the heck is going on here? And we talked about why the House of Representatives should have 6,000 people instead of 435. Also, great convo. Knox is here. Oh my goodness. Says, I pulled this off Pacer this morning. Absolutely giddy to review. Thank you as always, Rob. So Knox Bierman is another criminal defense attorney from the great state of Texas. And yeah, it's just been crazy. Like lawyers are just, defense attorneys. We saw a treasure trove come in this morning from Team Trump. We got happy birthday to Dana. Dana in the house. Dana in the house over on Locals is having a birthday. Happy birthday to Dana. We're very grateful for you, Dana. Always jumping in the chat and saying hello. Hopefully you have a beautiful birthday. Norman's here. Says value plus Trump being punished for doing a good job. Like value plus reminds me of like the store brands. Like this is a value plus prosecution or something like that. From Tish. Good to see you, Norman. Thank you for that. Ray Rock is here, says, this reminds me of when I was serving and ordered to apologize to someone. I would always say I was ordered to apologize, so I'm apologizing. It's just right. It's just like, all right, whatever. Yeah, I'm going to plead guilty so I don't rot away in custody for 20 years, so I'll just do it. Fred's here. 4 down, 15 to go. What a strong case, Fani. Well, her trajectory is not good. And these are like the big names. Sidney Powell, Jenna Ellis. We'll see what Rudy gets. Knox is here. The defense attorney from Texas says, people who don't do criminal defense for a living have no idea how awesome these plea deals are. Shout out to Knox over from Texas. I couldn't agree more. Like these deals are basically dismissals. Like they're basically dismissing the charges. Okay. Like relative to what they were charged with, Sidney had 7 felonies. She has 6 years of probation. It'll be probably, I don't know if hers will be terminated early, but the others will. Hers probably will too once they figure it out that they missed that in her plea. So they are just smoking deals. Like it's almost a total dismissal. You'd be really hard pressed to say you shouldn't do it. NY's here says, if she also was a lawyer, how could she be forced to testify of any discussions with Trump without piercing attorney-client privilege? So she wouldn't. That would be explicitly precluded, and they mention that in the actual plea deal. Hey, Adesia says, hey, Rob, can I put in my will, I will not vote Democrat after I'm dead? Yeah, but then you have to expect the Democrats to care. Yeah, they don't care. You're voting for Democrats either way, all right? That's just how they operate. Rocky's here. What's up, Rocky? Says, great show once again, Mr. Gouveia. Appreciate your efforts, man. Says, what do you think? The machine won't charge all of these pleas with violating conditions of the deal in the future if needed. Do you think that they will not charge them? So I don't think so, because I don't think so. I think that they have an interest in in having them go away. Like they want the cases to go away because they don't have any real impact on it. And more important question says, your thoughts, if any, on bread versus breadcrumbs in meatballs, or maybe meatballs with breadcrumbs versus without breadcrumbs. And I don't know. I'd have to consult with my mama to see how she makes her meatballs. That would tell me whatever mom does. I don't know. Whatever she puts in them is what I eat. So that's about my opinion on them. And thank you, Rocky, for the very generous dono. And I think that like Fani wants these cases to go away. Honestly, I think she wants them gone. Husky Mom is here, says, great show. Thank you, Husky Mom. It was a lot. We tried to squeeze a lot in today. As you can tell, we're running short on time just a little bit because there was just so much to unpack. But thank you, Husky. Let's say hello to our friends on the X platform briefly before we jump over to our members only after party. And YouTube members, don't forget to grab the Telegram link so you can join us in the after party later. We've got, hey, what's up? Norman Lee Smith. Hey, check this out, my friend. So I'm not going to play this one here, but check this one out. Norman Lee Smith says, great live stream, Rob. I rocked my Trump 2024 song last weekend in Polk City, Florida. That sounds good, man. I'm sure you're jamming out. Okay, so my friends, make sure you're over on our X platform so you can hear that amazing song. Danny McWilliams is here. Watching this, says, no one said Trump told me to do it. From Danny. V's over there says, these plea deals are only good for them. Of course they are. They're not the real target. You and I are. How long before this is used for mass incarceration for speech? We're watching the tools of our own demise being created. The needle has now been moved. From V. Danny says, I wonder how many book deals are in the works over the trials. Fred says, what's the point of a bench trial when the judge hates your guts? And we had some other people. Hey, George is here. What's up? George says that there were 20 to 50 people today. Thank you so much for explaining deferred adjudications. Good stuff. Thank you, George, for being here. RD7 is in the house and says, talking about election fraud. This one came out. Ex-Chief Mark Meadows granted immunity. Tells special counsel he warned Trump about 2020 claims. Ooh, so maybe Mark Meadows flips, right? That could be another story too. Good question. There's a lot of moving parts here. And again, even if Meadows warned Trump, he's allowed to have a different opinion. And so that, my friends, is it for us on the day. We are jumping over for just a short minute over at watchingthewatchers.locals.com. So come and check us out. Hang out with us there. We also have our website. So if you miss anything on the show, we'd love it if you went over to robertgouveia.com. This is what the website looks like. You can click this button right here. Click here for instant access. You'll get access to the mind map, but you'll also get signed up for our daily newsletter that will deliver these various reports right to your inbox every morning after the show. So sign up robertgouveia.com for our newsletter, and that way we never lose touch in case something happens on one of these other platforms. We also want to say what's up and thank you to our mods and our meme smiths who mod down the fort for us, starting with our friend Vienticus Prime in the house, K-Bean, we got Just Cause, we got Playin' Hooky, Ronnie's here, Zulu's here, we got Beyond Geo, Zach Nichols, John Allen, Janek, Dog Digger, Donut Mind Me, and John McGarvey with Vienticus clipping away for us today. Appreciate everybody modding the fort down for us. Shout outs to Geegum Geegum, Sleepy Dog Lee, and Nathan N810, all meme smith in the fort up for us. But that, my friends, is it for us on the day. We did cover some good ground. We are going to be back here tomorrow to get into it. We've got more Trump documents from his motherlode. Well, maybe we'll see another plea deal. Who the heck knows? There's going to be a lot to unpack. And the important thing is that we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.